Major win for the Second Amendment out of the United States Court of Appeals for the 10th Circuit in the case of Ortega versus Governor Grisham. Specifically, New Mexico's waiting period has gone bye-bye. At least, I should say, it's been preliminarily enjoined by the 10th Circuit Court of Appeals. Major win for the Second Amendment, 2-1 decision. Let's break it down when we come right back. Hey folks, I'm Mark Smith, host of the 4 Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. The 7-day waiting period enacted by New Mexico in 2024 has just been declared unconstitutional under the Second Amendment by the United States Court of Appeals for the 10th Circuit. Fantastic news. Bad news for the anti-gunners in New Mexico. This is a 2-1 decision. The majority points out that the waiting period law implicates the text of the Second Amendment because it implicates and restricts the right of the people to keep, which means to possess, and to bear, which means to carry arms, because you cannot first and foremost keep or bear arms if you do not first and foremost acquire them. And because this waiting period of 7 days applies to virtually everyone in the state of New Mexico, guess what? That restriction limits or temporarily freezes your ability or prevents you from exercising your Second Amendment right, a fundamental right. Because this would never fly in any other right, obviously it is indeed an infringement, a restriction, a hindrance on your ability to keep and bear arms because it is delaying you 7 days to be able to exercise your fundamental right. It is textually implicates the text of the Second Amendment, which means the burden shifts to the government. And the government, according to this 2-1 judge panel, this 2-1 victory for the Second Amendment, the government could not possibly come up with any kind of arguments as to why there's a historical tradition going back to 1791, our founding, that would justify and be relevantly similar to the modern-day gun control law, this waiting period. Just to jog your memory, this just 7-day waiting period, which we've talked about on this channel before, is, of course, designed supposedly to prevent people from rushing out there and engaging in gun violence, propaganda term, or an impulsive suicide, whatever it is. So they want to delay everyone who wants to acquire a gun from an FFL 7 days, just because it almost presumes that the people of New Mexico are incapable of exercising their fundamental constitutional right to keep and bear arms. And there's a whole bunch of restrictions associated with this Waiting Period Act. Moreover, there is no individualized determination. They don't say, well, we think Mark's okay, he can have a gun right away, but Bob, on the other hand, needs to wait 7 days. No, there's no individualized determination about anyone in the state. Everyone in the state, with some very minor exceptions, has to wait 7 days, no matter how fast the background check gets enacted, by the way. In other words, even if you go in there, you go to the FFL, your background check, your NICS check passes immediately in a matter of minutes, let's say, you still have to wait 7 calendar days to get the gun under New Mexico law. Well, the court said that's a no-go zone because you're slowing down the ability of individuals in New Mexico to exercise their right to keep and bear arms. And because that implicates the conduct or the text of the Second Amendment, the burden shifts to the government. And because the government cannot show a historical tradition of firearms regulation going back to 1791 when the Second Amendment was enacted, this law is simply not constitutional. Here's what the court had to say in its finding that this law had to go bye-bye. The lower district court found that a 7-day wait period did not infringe on Second Amendment rights, since the right to acquire a firearm does not impede the right to keep or bear a firearm. And in any event, the Second Amendment tolerates cooling off periods. We, however, disagree, and we reverse and remand this case. Cooling off periods infringe on the Second Amendment by preventing the lawful acquisition of firearms. Cooling off periods do not fit into any historically grounded exceptions to the textual right to keep and bear arms, and it burdens conduct within the Second Amendment scope. In this preliminary posture, because again, this is a preliminary injunction argument, we conclude that New Mexico's Waiting Period Act is likely an unconstitutional burden on Second Amendment rights of its citizens. We also conclude that the other preliminary injunction factors are met and that plaintiffs are entitled to an injunction. That's fantastic news. And what I really like about this decision is they really go into detail about why the right to acquire a gun is part of the textual right of the people to keep and bear arms, even though the words the right to purchase, the right to acquire, the right to procure does not appear expressly in the text of the Second Amendment, but this court analyzes it correctly to point out that it's long-standing black letter constitutional law, Supreme Court precedent that says that if there's some sort of necessary condition or some act that's closely related to the textual right, that act, that concomitant right, that ancillary right, whatever you want to call it, is indeed part of the constitutional text and protects that right. And that's what this court has to say. Here's what the court had to say about why the right to acquire is part of the textual right to keep and bear arms. As paper or a computer is a necessary predicate to the right to print, or the ability to own property is a necessary predicate of the right to just compensation for a taking, acquiring, purchasing, and possessing firearms is a necessary predicate to keeping and bearing them. Of course, the words purchase, sale, or similar terms describing a transaction do not appear in the Second Amendment, but the right to keep and bear arms surely implies the right to purchase them. It goes on to say, the court says, one cannot keep or bear arms if one cannot acquire them. And that's powerful language, but then goes on to talk actually about Justice Scalia himself and how he explained why these concomitant rights are equally protected to anything found expressly in the text of the Constitution, including the Second Amendment. Here's what the court had to say about that. The Waiting Period Act burdens Second Amendment rights. Common sense dictates that the right to bear arms requires a right to acquire arms, just as the right to free press necessarily includes the right to acquire a printing press, or the right to freely practice religion necessarily rests on a right to acquire a sacred text. Legal interpretation follows that common sense. When a text authorizes a certain act, it implicitly authorizes whatever is a necessary predicate of that act, citing to Justice Anthony Scalia and Brian Garner. It also cites to Clarence Thomas here, pointing out that constitutional rights implicitly protect those closely related acts necessary to their exercise. Bingo, bingo. You can't carry a gun, you can't possess a gun if you cannot acquire it. And by the way, side note, for those of you who want to ensure that we have the Supreme Court one day recognize we all have the right to make our own firearms, which is the correct answer. We need to first win. We have the right to acquire firearms under the text of the Second Amendment. Once we win, we have the right to acquire them under the text of the Second Amendment by the U.S. Supreme Court. That is the next step to get to where we want to get, which is a recognition that we have the right to make our own firearms, which I think we do, but it's always important to get the Supreme Court to agree with us and set that legal precedent. But I digress. But let's go on to talk about this waiting period. So then the court turns to and says, well, wait a minute. Let's discuss whether or not a 7-day delay in acquiring a firearm implicates the Second Amendment. And the court says, obviously it does. This would never fly with any other constitutional right. Here's what the court had to say about that. The burden imposed by a cooling off period is brought into sharper focus when considered in the context of other constitutional rights. A carte blanche 1-week cooling off period to publish news stories? Unconstitutional. A prior restraint is not constitutionally inoffensive merely because it is temporary, the court points out. The court goes on to say, temporary closures of churches during COVID-19? Obviously unconstitutional, citing the cases. If a criminal defendant had to wait 30 days after his arraignment before he could seek legal counsel so that he would not unduly resist his prosecution, obviously unconstitutional, the court points out. And then the court says the Second Amendment is no different. The constitutional right to bear arms is not a second-class right, subject to an entirely different set of rules than the other Bill of Rights guarantees. So that's great language there, great discussion and analysis by the 10th Circuit 2-1 decision by the 10th Circuit panel, in this case of Samuel Ortega versus Michelle Lujan Grisham out there in the 10th Circuit. But I also want to point out a couple other things that the state of New Mexico argued. One of the things they argued was that the Supreme Court has in dicta pointed out that there can be additional conditions placed upon so-called commercial transactions. And because acquiring a gun from an FFL, from a gun store, is a commercial transaction, those rules are presumptively constitutional. And the court here made two very powerful points. The first point it made was, well, first of all, there are non-commercial transactions that are covered by the 7-day waiting period. They point out that a collector donating his gun collection to a museum would be subject to that 7-day delay in the transfer of the collection. They point out, obviously, if you give a gun to a gift, it's a 7-day delay before that can be transferred with the FFL. So they point out that there's obviously non-commercial transactions that are covered by the 7-day waiting period. And moreover, it points out that even assuming this is a commercial transaction, rule or a regulation on a commercial transaction, that only means at most it's presumptively constitutional, but that doesn't prevent a Second Amendment claimant, a rights claimant supporting the right to keep and bear arms, from overcoming that presumption. Like you and I have, we are presumed innocent in a court of law. That does not prevent the government from proving beyond a reasonable doubt that we are criminals, that we committed some crime. So again, just because there's a presumption in favor of something does not mean that that presumption cannot be overcome. So the court here points out that even assuming there's some sort of presumption in favor that government regulations on commercial transactions are presumptively constitutional, in this particular instance, that was overcome by the fact there's no historical tradition of firearms regulation analogous to a universal 7-day waiting period. So there you have it, folks. Great news. The 10th Circuit Court of Appeals 2-1 said that the Second Amendment rights claimants, the Second Amendment plaintiffs, are entitled to an injunction enjoining on a preliminary basis this 7-day waiting period there in the state of New Mexico. Great decision here. I urge you to read. I'll put a link to it in the description below. Let me know if you have any comments or criticisms about my analysis here. And again, thanks again for tuning in. I appreciate your support. Make sure you follow me over there on X @4boxesdiner. Don't forget to follow me and subscribe here on YouTube and on Rumble. And I'm looking forward to talking to all of you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.